Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured workers. It's Mike Cardamone here. Today I wanted to talk about notice under the Pennsylvania Workers' Compensation Act, and specifically what's called the discovery rule. Now, in general, if you have a work injury in Pennsylvania and you're an employee, you have 120 days to give notice, 120 days from the date of injury. There are some occasions, though, where an injured worker doesn't really know if their condition or injury is work-related. And so the discovery rule basically means that in certain circumstances, the time for giving notice of an injury does not begin to run until the employee knows, or by the exercise of reasonable diligence should know, of the existence of the injury and its possible relationship to his or her employment. So this was added by Act 223 in 1972, and it really codifies well-established law. So reasonable diligence is an objective standard, not subjective. And one thing you want to keep in mind with respect to this is that your mere suspicion or intuition or belief that your condition is work-related or your injury is not sufficient to trigger the obligation to give notice, absent a medical opinion that an illness or disease is related to employment. So there's a case called Allegheny Ludlam Corp. and versus the WCAB. It's a Commonwealth Court case from 2010, which basically stands for the proposition that an injured worker or their attorney should consider obtaining an opinion of causation before issuing notice to the employer. So the discovery rule is really important because it can give you some extra time beyond the 120 days to establish notice. Remember, notice is really important. If the workers' comp judge finds that you did not give notice within the proper time frame, it's game over. It doesn't matter how serious your injuries are. They could be catastrophic, and you're not going to have a case. And also remember this concept. You're not going to get any wage loss benefits until you give notice. So the earlier you give notice, the better. Does it have to be written notice? No, although written notice is going to be better. But you need to be careful with that. I've heard of situations where an employee wrote a letter and then they put it under their manager's door, according to their testimony, and that was not sufficient to establish notice. The court basically said the injured worker has to prove actual receipt in that situation by the employer or by the manager. So this always goes back to the same thing we always talk about. Get a workers' comp lawyer as soon as you sustain an injury. You're going to avoid falling into a lot of traps and a lot of difficulties. And notice is a really tricky issue, and a lot of people make a mistake with it. Another example is they try to tough it out. They think they just sprain their back or it's going to go away. It's not going to be serious, and they don't want to cause any waves. Most people actually want to keep working. And so, and there's also an environment and culture at a lot of places to intimidate people from bringing forth work injuries. In fact, some places will give out bonuses to injured workers who don't have any work injuries or report any. So the bottom line is that you want to give notice. You want to be clear about it. You want to give it as soon as possible. And in situations where, you don't know, the discovery rule can help you out. And you really want to make sure you get to the doctor first if you can to get that opinion about whether your condition is most likely related to your work environment. A lot of times those cases involve things like occupational diseases like asthma or things like that. In most cases, people know if their condition was work-related. If they're lifting a box and they're bent over and they can't get up and they have back pain, that triggers the 120 days right then and there, because you know that it's a work injury. There's no doubt about it. So just keep these things in mind. Notice is a really important issue. We probably talked about it in a previous podcast. If you have any questions, always call us, please. 215-206-9068. As always, you can email me directly. It's Michael, Michael, at cardamonelaw.com. So Michael at CARDAMONELAW.com. And you can find us online, of course, at cardamonelaw.com. And we have a very popular blog that's paworkinjury.info. So hopefully we'll hear from you. That's all for now from Cardamone Law University, and we'll talk to you soon. Thanks.